So we've put together a document that I think has all of the stuff on it that you guys need to put on your document. So we'll start here. Doesn't really matter if it's child support or if it's just the state. If you're dealing with a commissioner or a magistrate or whatever the hell they call these fake judges. Here in Salt Lake, they call them administrative law judges. ALJs, they're clerks, okay? They're not real judges. And we're going to go through a bunch of court cases and precedent that might help you out. So let's look at this here. First of all, this is, if you double click, you can put in your header your certified mail number, okay? And then you just double click again and it goes in there, and that is something that is important in all your documents so that you can prove that you mailed to it, because they are going to ignore you. Okay, so this was just real quick. We put the date, the first attempt. So you're going to probably send them special appearance, validation of debt letters, void judgments, and why. You're going to use federal rules of civil procedure. You're going to use everything, but they're just going to ignore you. Okay? So in most administrative processes, it's just like the Wizard of Oz. It's click your heels together 3 times, Dorothy, and you can go home. Okay? So 3 attempts, and then you can take them to court, and assumingly, if you follow the administrative procedure and the process, if they don't verify and send you the documentation that you want, and they just ignore you because they're ignorant and they're arrogant, you should be able to go in and get it dismissed by either small claims or the regular municipal court that you go to. So let's look at this real quick. So first of all, you will put your name, address, zip code, email, phone number, whatever. That's who it's from, of course. And then you put the child support thief, their mailing address and info. That's got to be on there. So who it's from, who it's to. You put your case number and the judge, okay, and your attempt number, okay. So the second time you send this out with a different mailing number, you will go in and you will just change that to a 2. Okay, real simple. Okay, this is a Word document, and you can get it from me if you want. But let's go through it. You would put your motion to dismiss, or your motion to vacate, or judicial notice, or whatever you're going to title this. This is a void judgment. Okay, so you would put, motion to vacate, void judgment. Okay, or whatever other heading you want to put on here, to the state of Wyoming, blah, 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 district court. Okay, so you put that in there, and you guys, if you know anything about Word documents, you can just go in here and okay, you can just go in here and you go to home, and your little screen pops down, and you can move it around. You can put it over there, you can put it over here, whatever you want to do. You want to center it, whatever. Okay, so that's going to say your 3rd District Court of the state of whatever the fuck, okay? So let's see what this says. This is a notice of void judgment. I, me, myself, also known as, and then you put your name in, a man living, well, if you're a woman, then you put a woman living on the land without the corporation called the state of whatever, okay, whatever state you're in, do hereby provide notice of void judgment by declaration as follows. I am not under your corporate jurisdiction, and say the following, okay? Whenever a judge or a fake commissioner, magistrate, ALJ, administrative law judge, whatever yours is called in your state, is dealing with a statute like your state government code or your state penal code or your state code of civil procedure, you become a clerk working for the prosecutor. Okay? Judges who become involved in enforcement of mere statutes, civil or criminal in nature or otherwise, act as mere clerks of the involved agency. Okay? And that comes from Casey Davis, Administrative Law, Chapter 1. And if you want to, cut and paste that, you can do this. Okay? And then you can go to Google. Okay? You can right click on it and copy that and paste it into your browser, and that'll come up and you can read the whole thing. Well, that goes with all these. Okay? So it is an accepted rule, not only to state courts, but to federal courts, that when a judge is enforcing administrative law, they are described as mere extensions of the administrative agency for superior reviewing purposes as a ministerial clerk for an agency. Okay? So in other words, they're a clerk. They're not a judge. Administrative law judge is not a judge. Okay? They call themselves judges. They're not judicial. Okay? So when you go in front of a magistrate or a commissioner, they are not a judge and they cannot make judicial decisions. When acting to enforce a statute and its subsequent amendments, to the present date, the judge of a municipal court is acting as an administrative officer and not in a judicial capacity. Okay, that's Thompson versus Smith, Keller versus PE. Okay, you can look them up. What's that? FRC versus GE. That's the United States Supreme Court right there. Okay, when a judge is operating as a clerk, masquerading as a judge, he cannot, let me change this real quick because it's not a capital. It's a lower because it's just a regular old peon. He cannot do anything judicial. And if he attempts to do something judicial, it is a nullity. And this is Burns versus Superior Court. Okay, you can look that one up. Once jurisdiction is challenged, it must be proven. So this is another thing I didn't mention. You'll notice everything's labeled or numbered, not labeled. So this talks about judicial. Okay, this talks about judicial and judicial capacity. Does not act judicially. Okay, and then we get into jurisdiction. Once jurisdiction is challenged, it must be proven. Here's all the case laws for that. Okay. Number 3, the defendant, that would be you in the case, has previously served notices upon, okay, and you would put your child support agency, try to get their name, whatever, and their superiors, and have both ignored all attempts to validate their authority to bother me. And the defendant filed challenges to jurisdiction, probably by special appearance. Okay, if you've gotten paperwork from anybody out there, it's probably in there somewhere. And these individuals have not answered one word or even attempted to prove jurisdiction. Okay? 4, in order to prove jurisdiction, there must be a contract. Okay? It is impossible to prove jurisdiction exists absent a substantial nexus with the state, a contract with the state, such as voluntary subscription to a license. Okay, now we've been through this before. If you've got a driver's license, if you've got a birth certificate, if you've got a marriage license, okay, you're in contract. But part of that is going through the terms and conditions and full disclosure and threat, duress, and coercion. That's a whole nother video. We've been through all that. You didn't know that getting married gave the state an interest in your child. Okay, so you can bring that up if you want. In order to prove jurisdiction, there must be a contract. No corporation has standing to do anything in court. So if it's, the state of New York, state of Utah, state of California, okay, against, and they're the plaintiff, and you're the defendant, what does this say? My opinion is, and long has been, that the mayor and alderman considered corporation, or the president or the directors of a bank, or the president and directors of a railroad company and of similar corporations are the true parties that sue and are sued as trustees and representatives of the constantly changing stockholders. A corporation, therefore, being not a natural person, a man or a woman, but a mere creature of the mind, invisible and intangible, cannot be a citizen of a state or of the United States and cannot fall within the terms or the power of the above mentioned article, and can therefore neither plead nor be impleaded in the courts of the United States. Okay? So what does that say? It says, in other words, the state of New York, Utah, California, whatever, is a fiction. Okay? Doesn't exist. They cannot file charges against you because they don't exist except in name only. And they cannot bring a man into court. Okay? A judge ceases to sit as a judicial officer because the governing principles of administrative law provide that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgments for that of the agency. Okay? So they have to be third party. They have to be non-biased. They cannot be part of the system. And we all know that when you go into that frickin' courtroom, the cops, the lawyers, the prosecutors, the clerks, the judges, everybody works for the state. So how do you get a third party intervener, adjudicator, to oversee your case? You can't. So the whole thing's void. The clerk masquerading as a judge committed treason and seditious conspiracy pursuant to your own state federal codes, because when a judge acts where he or she does not have jurisdiction to act, the judge is engaged in treason. Okay? There's the United States versus Will, Combs versus Virginia. Okay? An unconstitutional act is not law. It confers no rights. It imposes no duties, affords no protection. It creates no office, and is in legal contemplation as inoperative as though it had never been passed. Okay? Shelby versus Norton. An unconstitutional law is void and has no law, and is as no law. An offense created by it is not a crime. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Okay, that's from American jurisprudence. When a clerk, masquerading as a judge, deliberately uses invisible contracts to enslave a man, he walks away from any immunity he may enjoy and becomes personally liable. Okay, so you can sue them in their individual capacity because what they're doing is not judicial, and you can go after them in their individual capacity. The decision of this kangaroo so-called court is brutum fulmen, which is an empty noise, an empty threat, a judgment void on its face, which is in legal effect no judgment at all. Okay? Doler versus Pratt. Okay? Corpus Juris Secundum. Black's Law Dictionary. Okay? You can't argue with this stuff. All of your assumed authority is under color of law. Okay? Here's all the stuff about color of law. We've been there. Stop it. You can look at it. Okay? The clerk, masquerading as a judge, knows that it is my right to have a neutral and detached judge, but instead chose to conspire with, then you would put the child support agency, the district court, the prosecutor, the child support bitch that's calling you every week saying, where's my money? And thereby participated in a fraud and a nullity. Okay? It's a fundamental right of a party to have a neutral and detached judge to preside over the proceedings. Do you think these people are neutral and detached? Hell no. They're all getting paid by the state. It's all void. Okay? Now, they assaulted the defendant with their corporate codes and statutes, and the defendant was served hundreds of documents on them and their superiors stating that the defendant is not interested in participating in their commercial transaction, and so is their accomplice. Okay, so you'd put the lady or the guy or whoever, okay, or child support agency as their accomplice, okay? They assaulted the defendant with their criminal corporation. Okay, this says that same thing as above, that it's not a real person, it's just a corporation. Okay, so you put so-and-so is paid directly from the state of whatever. Therefore, you have an interest in this case and cannot oversee the case. Henceforth, you are fired and your administrative clerical decision is void. Okay? For all of the foregoing reasons, all of the orders, judgments, and decisions in this case are absolute nullities and void ab initio, which is void from the beginning. Where there is no jurisdiction, there is no judge. A void judgment is one which, from its inception was a complete nullity and without legal effect. Void judgment is one that has no legal force or effect whatever. It is an absolute nullity. That's City of Lufkin versus McVicker. A void judgment, insofar as it purports to be a pronouncement of court, is absolute nullity. There's Thompson versus Thompson. Void order may be attacked either directly or collateral at any time. Okay. A void judgment is one which from its inception is and forever continues to be absolutely null and without legal efficacy, ineffectual, to bind the parties or to support a right. Okay? Not every action, by any judge is an exercise of his judicial function. It is not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when a judge does not follow the law, he loses subject matter jurisdiction and the judge's orders are void. Okay? So we got a whole bunch more here. These here, if you look right here, these are all maxims of law. These are hard to say. Okay? Out of fraud, action, no action arises. So fraud from the beginning. Okay, once a fraud, always a fraud. Things invalid from the beginning cannot be made valid by subsequent act. Okay, a thing void from the beginning does not become valid by lapse of time. Okay, there's a bunch of these maxims of law. Okay, and everything these child support, pigs. Okay, what is pig? Well, let's look at pig. Whoop, I skipped it. Where is it? Okay, there it is. Sorry, I went right by that. What's PIG? PIG is an acronym which stands for Persons in Government. Okay? So, when you talk about pigs, you're talking about people in the government that are trying to steal your money. Okay? For their own monetary gain. So, everything these pigs do, or these administrative law judges, or these commissioners do, or pigs do, is a fraud and a lie, and they get their puppets to help them with their assault, kidnappings, false imprisonments, and thefts of property for their own monetary gain. Fraud and deceit may arise from silence where there is a duty to speak. Fraud may be committed by failure to speak when the duty of speaking is imposed as much as by speaking falsely. So, tell me, sir, did the Child Support Agency, did you, Commissioner so-and-so, tell me that you were not a real judge? Did I give up any of my God-given rights to a jury trial? Did I give up my right to raise my child as I see fit? Was I coerced into some unseen contract with the state? Can you prove in a court of law that you and your company have an interest in my property? Can you and your company prove in a court of law that you can seize property without a warrant? There's a couple of Bible passages, and here's the bottom. Okay? This is where the notary goes. You sign, non-domestic, non-assumpsit. You always put your zip code in brackets because if you don't, then you're admitting that you're in federal jurisdiction. If you use a zip code, you are in federal jurisdiction and they can book your ass. LS, what does LS mean? That's living soul. Okay, so you're a man. Sign this in front of a notary, get it notarized, and good luck.